Greetings from India Business Insights and welcome to this new video on international arbitration. Before getting into how international arbitration works and why companies considering doing business in India should opt for arbitration instead of the usual court procedure, I would like to first explain what arbitration means. It is a form of alternative dispute resolution, although there are other forms of dispute resolutions such as conciliation and mediation. Arbitration is the most popular form of dispute resolution in the world currently. Simply put, it is a way to resolve disputes outside the courts. A dispute will be decided by one or more persons called the arbitrators or arbitral tribunal, and this arbitrator or arbitral tribunal, after hearing the said dispute, will render the judgment which is known as the arbitration award. An arbitration award is legally binding on both sides and it is also enforceable in the court of law. International arbitration is a consensual, neutral, binding, private, and enforceable means of international dispute resolution. It is usually faster and less expensive than domestic court proceedings, particularly in countries like India, where the court procedures could be somewhat slow and less expensive than in countries like the US or UK. Unlike domestic court judgments, international arbitration awards can be enforced in nearly all countries of the world, making international arbitration the leading mechanism for resolving international disputes. Being a cheaper and faster alternative to the conventional judicial method, often cross-border agreements between two parties have the provision of international arbitration. It has firmly established its utility over all others and is truly a real alternative to judicial adjudication. The use of international arbitration has evolved to allow parties from different legal, linguistic, and cultural backgrounds to resolve their disputes in a final and binding manner, usually without the formalities of the procedural rules of other legal systems. International arbitration is sometimes called a hybrid form of international dispute resolution, since it blends elements of both civil law procedure and common law procedure by allowing the parties a significant opportunity to design the arbitral procedure under which their dispute will be resolved. Little bit on the history of how international arbitration came to be. Post-World War II, there was an increase in globalization of trade and businesses, which led to a growing need for dispute resolution between companies which conducted businesses in different countries, and that's when the need for an arbitration process arose. A treaty called the New York Arbitration Convention was agreed on in 1959, adopted by 154 of the UN members, and more than 65 countries have participated in arbitration decisions. The New York Convention provides for court recognition and enforcement of foreign arbitration decisions, allowing arbitration proceedings to override the authority of domestic jurisdictions across the world. Why should one opt for international arbitration to resolve a dispute rather than a traditional court litigation? International arbitration can resolve disputes more swiftly than a traditional court litigation since there are only limited appeals from arbitration awards. It can be less expensive than traditional court litigation. It can provide better quality justice since many domestic courts are overburdened, which does not always allow judges sufficient time to produce legal decisions of high quality. Clients can play an active role in selecting an arbitrator who is an industry expert in international arbitration rather than a generalist like many domestic court judges. International arbitration is flexible, and the individual parties to a dispute play a significant role in selecting the procedure that is most appropriate for resolving their dispute. It is confidential, which is useful if the parties wish to continue their business relationship or to avoid negative publicity. It is neutral. This is very important for cross-border transactions since it avoids the possibility of a home court advantage for one party. In certain countries, judges do not rule independently. In international arbitration, an award must be independent or it cannot be enforced. With the convergence of foreign investments and overseas commercial transactions, international commercial disputes are occurring frequently. Including in India, These disputes are constantly rising. This has drawn huge attention from the international community on India's international arbitration regime. The Indian government enacted the Arbitration and Conciliation Act in 1996 in an effort to modernize the then existing Arbitration Act of 1940. This act repealed all the three previous statutes on arbitration. Its primary purpose was to encourage arbitration as a cost-effective and quick mechanism for the settlement of commercial disputes. It covers both domestic and international commercial arbitration. Subsequently, the Act was amended in 2015. The amendment tackled the problems of delays by providing strict timelines for the completion of arbitral proceedings, in addition to widening the scope for resolving such disputes via a fast-track mechanism. With respect to the evolution of international commercial arbitration, in 1978, the Ancestral Secretariat, the Asian African Legal Consultative Committee, the International Council for Commercial Arbitration, and the International Chamber of Commerce met for a consultative meeting where the participants were of the unanimous view that it would be in the interest of international commercial arbitration if UNCITRAL would initiate steps leading to the establishment of uniform standards of arbitral procedure. The preparation of a model law on arbitration was considered the most appropriate way to achieve the desired uniformity. The full text of this model law was adopted on 21st June 1985 by UNCITRAL. This is a remarkable legacy given by the United Nations to international commercial arbitration, which has greatly influenced the Indian law. In India, the model law has been adopted almost in its entirety in the 1996 Act. The Indian Arbitration Act of 1996 defines international commercial arbitration as one ascending out of a legal relationship that is considered commercial, irrespective of whether either of the parties is a foreign national or resident, or is a foreign body corporate, a company, association, body of individuals whose central management or control is in foreign hands. Therefore, an arbitration having its position in India but including a foreign party shall be naturally subject to the provisions of this Act. But in the event that the international commercial arbitration is held outside the territory of India, the Act obviously has no applicability owing to the lack in jurisdiction. Speaking about the rules applicable to the arbitration proceedings, in the Indian Arbitration Act, an arbitral tribunal shall decide the dispute in accordance with the substantive law for the time being in force in India. However, in case of international commercial arbitration, the arbitral tribunal shall decide the dispute according to the law specified by the parties. If no law is specified by the parties, the arbitral tribunal shall apply the rules considered to be appropriate according to the circumstances of the dispute. Now let's talk a little bit about the place of arbitration, given that the crux of arbitration is consent by parties, where parties are free to agree to the procedure concerning arbitrations, including the place of arbitration. Parties normally agree to arbitration by means of an arbitration clause in a contract made by them before a dispute has arisen, although in some cases it can also be agreed upon after a dispute has arisen. To give you a simple example, say you have Company A and Company B, whereas Company A is based out of India and Company B based out of Singapore. Companies A and B enter into a business agreement and they both agree that in the case of a dispute, they shall amicably resolve it via arbitration. They further agree on where they want this arbitration to take place while also choosing the appropriate jurisdiction. Say that A and B agree that India will be their seat of arbitration. Therefore, in the event of a dispute, the parties will meet in India to begin the arbitral procedure. This is how a model clause in an agreement between two companies looks. Here, the arbitration is administered by the Singapore International Arbitration Centre in accordance with the arbitration rules of the SIAC. The seat of arbitration is in Singapore. The language used is English. And finally, the governing law of the contract would be the substantive law of India. Until now, the preferred seat of arbitration has been Singapore or London. While occasionally arbitration awards may be challenged in the Indian courts, within the framework of the Indian law and the international conventions, generally these arbitration awards have been enforced in India without any problems. Indian firms may be occasionally reluctant to consider international arbitration in smaller value contracts due to the fear of travel and other costs. For such contracts, the contracting parties may consider India as a seat for arbitration. When it comes to confidentiality, the parties usually have a lot at stake, since any decision passed in this regard holds massive importance to not just the business but also the reputation of the firms or the parties involved. In court litigation, the decision becomes a matter of public record, whereas the confidentiality offered by the arbitration process attracts all such parties that do not wish for the terms of their settlement to be known. Moving on to the procedure for the appointment of the arbitrators, which usually depends upon the seat of arbitration. Nevertheless, a person of any nationality, that is not just pertaining to the nationality of the parties involved, can be appointed as an arbitrator. It is important to note that the parties have complete freedom to choose their arbitrator. Moreover, they also have to mention how many arbitrators they wish to have. Normally, it's either one or three. In case of three arbitrators, each party shall appoint one arbitrator, and the parties together by agreement shall appoint the third arbitrator. Arbitrators must be impartial and independent at all times. In case any arbitrator is associated, prior or during, to any of the parties, he or she must disclose this information immediately, and another arbitrator will be appointed. Some of the important factors to weigh in while choosing an arbitrator are education, training and experience, professional standing, nationality, and language skills. Now to the last and crucial part, which is the enforcement of foreign awards. The provisions of this part are based on the New York Convention and the Geneva Convention, respectively. In the Arbitration Act of 1996, a foreign award is defined as an award of dispute which arises due to the legal relationship between the parties, whether contractual or not, but commercial in nature. Regarding the enforceability of the foreign award, the Indian Act merely empowers the court to declare that the foreign award is enforceable under the provisions of this Act, and moreover, at the moment such a declaration is granted, an award shall be deemed to be a decree of the court, and it is open to the parties to seek its execution in accordance with the provisions of the Code of Civil Procedure. So, in view of all the advantages of arbitration, if you are planning to do cross-border business, particularly in India, it is highly recommended that you put an option to use international arbitration in all your agreements. We at India Business Insights look forward to bringing you similar useful videos on the relevant international law and practices. We encourage you to like and comment on this video and would also appreciate if you would share and subscribe to this channel. Thank you.